Hey, what's up, y'all? I had to change my shirt. We are on page 119, Rich Dad, Poor Dad, section 5, protecting your assets, seeking safety, security, and insurance. So they're asking us, are you seeking safety, security, and insurance? Have them all with the ultimate asset protection entities available to you. So the asset protection entities available to you by Garrett Sutton, Esquire, or ESQ. I'm not sure what that means, but so in chapter 1, we're going to be reading Facing Financial Disaster. He's asking, chapter 1, Facing Financial Disaster, how to best salvage what you have. Bankruptcy, unincorporated or incorporated. Oh well, so they're talking about bankruptcy, but I want to wear a hat. I feel like I look better with the hat. Just don't feel a little itchy with that this one. But okay, how to salvage what you have. Okay, that's chapter 1. Chapter 2, when things are going all wrong, save what you can save. Homestead, income, retirement plans, personal property exemptions. Chapter 3, pitfalls you can avoid with jointly owned property. Pitfalls you can avoid with jointly owned property. Chapter 4, marital property, planned or unplanned. It makes a huge difference. 5, save it with family limited partnerships. Chapter 6, simple and smart estate planning made understandable for you. Wills that give and probate wills that give and probate that takes away. Living trusts, what they are and how they can work for you. Marital and family trusts, what they will do for you and your family. There's a lot of chapters in this one. They're very important. Chapter 7, do it right once with irrevocable life insurance trusts. Chapter 8, should you venture offshore with offshore asset protection trusts? Chapter 9, what about a limited liability company, LLC? Chapter 10, protect your intellectual properties with patents. What are intellectual properties? Chapter 11, protect your intellectual properties with trademarks. Okay. I have like something in my teeth. I can get it out. It's kind of like a little annoying. I had toothpicks at home. I wish I wasn't gonna eat that, but okay, let me read this little quote right here. Most fear in life comes from lack of knowledge, seldom from any real threat. You hear that? Most fear in life comes from lack of knowledge, seldom from any real threat. So that's a good one. Okay, so chapter 1, Facing Financial Disaster, how to best salvage what you have. Facing financial disaster, how to salvage what you have. Oh, there's an old receipt in here from like 2008, but so this one's not that long, guys. Chapter 1. So this is very important though. Facing financial disaster, how to best salvage what you have. Bankruptcy, unincorporated or incorporated. So case study 9. Jerry had problems that would not let him sleep at night. He was hounded by creditors. They called him at all hours during work, at home, in the middle of the night. He should have listened to his attorney and to his accountant and even to his grandmother. They all advised him to form a corporation to limit his liability, but for Jerry, going to a lawyer was like a trip to a dentist. He knew his business. He was an excavation and asphalt paving contractor, the best in the area. He didn't need to pay another $1,000 to another attorney to protect himself from an unanticipated risk. He rushed into his own contracting business as a sole proprietor, thinking that nothing would happen to his house, his personal property, or any other family asset. Business went smoothly and profitably into the Crown Plaza project, Adjoining property owners filed a lawsuit against Jerry and the general contractor, alleging $350,000 in damages to their property because of excessive dust from road construction on the project. And even though Jerry didn't think he was at fault, the local court didn't agree. Jerry now found himself jointly and severally liable. Severally, Severally, liable with the general contractor, a corporation. The contractor corporation filed a Chapter 7 bankruptcy with no assets to pay creditors. The corporation's bond was already tapped for $200,000 and a total of $150,000 was still owed. Jerry became physically ill upon learning that he was solely responsible for the remaining. So the person he was doing business with had a corporation. Responsible for the remaining $150,000. He had worked all his life to build up a nest egg for retirement. It looked as if all might be lost. Jerry needed to immediately understand his most basic asset protection right: declaring bankruptcy. Key points: bankruptcy can provide a certain measure of asset protection. Exemption planning can protect assets for use after bankruptcy discharge. Exemption planning can protect assets for use after bankruptcy charge. There you go. Bankruptcy courts are governed by the bankruptcy and judicial codes enacted by the United States Congress. The Bankruptcy Code is designed to establish uniformity in insolvency proceedings throughout the United States. In addition, the purpose of the Bankruptcy Code is to give the honest debtor a fresh start and to divide the assets of the bankruptcy estate equitably among the debtor's creditors. Unlike state law, which rewards quick and aggressive action by individual creditors, the rights of creditors are balanced under the Bankruptcy Code. Bankruptcy should not be viewed as a panacea to all debt problems. Panacea to all debt problems. Many prepetition debts, those incurred before filing for bankruptcy, including secured claims, alimony, and student loans, are not dischargeable and may still be due and payable after the case is closed. On the other hand, the filing of the bankruptcy petition stays all debt collection activities on most pre-petition debts. In addition, the debtors retain their exempt property in a liquidation and may retain all their property if certain requirements are met in a reorganization. The most common bankruptcy cases are Chapter 7 liquidation, Chapter 11 reorganization, Chapter 13. So the most common bankruptcy cases are liquidation, reorganization / adjustment of debts of an individual. In some circumstances, a debtor can convert a case from one chapter to another or dismiss it altogether. To take advantages of the protections afforded, it is important to be knowledgeable in the procedures of bankruptcy law. A good bankruptcy attorney can quite literally save a client's life, liberty, and pursuit of happiness. In determining which chapter of the code to file under, one must consider the scope of the bankruptcy discharge available, discharges and non-discharges of debt. In a Chapter 13 case, upon completion of all the planned payments, the debtor receives a super discharge in which all debts except alimony, student loans, DUI-related claims, and criminal fines are discharged. In a Chapter 7 or Chapter 11, in addition to the non-dischargeable debts under Chapter 13, other pre-petition debts are non-dischargeable, including but not limited to the following. Okay, so in a Chapter 7 or 11, in addition to the non-dischargeable debts under Chapter 13, other pre-petition debts are non-dischargeable, including but not limited to the following: money or property obtained by fraudulent or intentional misrepresentation. So money or property obtained by fraudulent or intentional misrepresentation, money or property obtained by fraudulent or intentional misrepresentation, certain credit card purchases, and cash advances. Claims for willful malicious injury or breach of fiduciary responsibility. Divorce-related property settlements. Hold harmless agreements that are not in the nature of alimony and support and certain tax claims. Okay, taxes. Taxes due on non-fraudulent filed tax returns that are due more than 3 years prior to the filing of the petition or assessed by the IRS more than 240 days prior to the petition are generally non-priority unsecured claims that are subject to discharge in all the chapter filings. However, priority unsecured tax claims are not affected by a Chapter 7 bankruptcy. Post-petition wages are not property of the estate in Chapter 7 and Chapter 11. Therefore, there is no stay or cessation of execution against post-petition wages. This means that the IRS can collect on wages earned after the bankruptcy. I mean, shit, you just have to get a good bankruptcy lawyer, man, because it's just hard to understand. Unlike Chapter 7, tax claims may be paid through the plan in Chapter 11 and Chapter 13. Since post-petition wages are a property of the estate, and in Chapter 13, the IRS and all other creditors are stayed from collection, provided that debtors confirm a plan and make monthly plan payments to the Chapter 13 trustee. Bankruptcy availability and rights. A Chapter 7 is available to individuals, partnerships, and corporations. In a Chapter 7 bankruptcy, the debtor keeps all his exempt property. When filed, the bankruptcy estate, a legal entity separate from the debtor, is created, and ownership of non-exempt property is transferred to the bankruptcy estate for sale by a Chapter 7 trustee. The trustee sells the property to pay creditors according to the distribution guidelines in the bankruptcy code. A debtor's income earned after the filing is not property of the estate in a Chapter 7. Chapter 7 debtors may use their non-exempt property and post-petition income to pay their ongoing living expenses. Chapter 13 is available to an individual with regular income. The term regular income has been defined very broadly. In Chapter 13, the debtors generally retain their property. The debtor is obligated to pay his disposable income to the Chapter 13. The debtor is obligated to pay his disposable income, just like extra money, I would say, to Chapter 13 trustee for payment to creditors for a minimum of 3 years. Disposable income is the net household income after the payment of monthly expenses, so everything left over. Additionally, unsecured creditors must be paid at least as much in a total third chapter. Additionally, unsecured creditors must be paid at least as much in total Chapter 13 plan payments as they would be paid in a Chapter 7 liquidation. Only individuals with unsecured debts totaling less than $250,000 and secured debts less than $750,000 are eligible for Chapter 13 relief. Corporations and individuals with debt over this limit must proceed under Chapter 7 or Chapter 11. In a Chapter 7 liquidation, unsecured creditors are paid their pro rata share of the proceeds of the sale of the debtor's non-exempt assets. As with the Chapter 7, Chapter 11 is available to all individuals, partnerships, and corporations. The Chapter 11 reorganization process is generally a much longer and more expensive process than either Chapter 17 or 13 proceedings. Congress has recently expedited the process for small businesses with unsecured debts of less than $2.5 million. What to do? Jerry's first decision was which chapter of the code to utilize. Since Jerry was doing business as an individual, he could file a Chapter 13 reorganization if he met the debt limitations. His next best option would be to file a small business Chapter 11. In any event, he generally wanted to remain in control of his business, keep his assets, and not lose his contractor's bond by filing Chapter 7. In a reorganization case, the automatic stay gave Jerry time to propose an orderly payment to creditors without the sometimes debilitating distraction of defending separate state court suits and collection proceedings brought by individual creditors. Jerry could propose a plan that might force his creditors to take periodic payments over a period of years. Jerry could propose a plan that might force his creditors. Okay, the keys for Jerry and others similarly situated are: 1. Creditors were forced to look to the bankruptcy estate and not Jerry in the middle of the night for payment. Okay, creditors were forced to look to the bankruptcy estate and not Jerry in the middle of the night for payment. 2. Exempt assets could be retained by Jerry for a fresh start. To his extent, bankruptcy provides asset protection. Exempt assets, meaning ones that they're not going to take from you, I don't think. Exempt assets could be retained by Jerry for a fresh start. To this extent, bankruptcy provides asset protection. Exempt choices. In bankruptcy, a debtor has 2 exemption choices. Jerry can choose to take the exemptions provided by the state and federal laws in the state in which he has lived for the last 180 days. Or he can choose to use the exemptions that the bankruptcy law provides. A wrinkle in all of this is that a state may opt out of the bankruptcy exemption scheme and force its citizens to use the state's exemptions. It is important to consult a local attorney to learn which rule applies. In addition, because moving to another state to declare bankruptcy is a utilized strategy, it is important to know the federal exemptions. In brief, Jerry's interests in the following. So, because moving to another state to declare bankruptcy is a utilized strategy, it is important to know the federal exemptions because federal is the whole country. In brief, Jerry's interests in the following are exempt and thus not distributed to creditors in a bankruptcy: a motor vehicle not exceeding $2,400, household goods and furnishings, clothes, books, appliances, and the like used for personal purposes by the debtor and his or her dependents in the total amount of $8,000, with each individual item not exceeding $400. Tools of the trade not exceeding $1,500. Jewelry for non-personal use not exceeding $1,000. No jewelry for personal use. Health aids prescribed by a doctor. Health aids prescribed by a doctor. Real estate interest, homestead not exceeding $7,500. That's a little bit, no? Unmature life insurance contracts, with some exceptions. A right to receive Social Security, disability, or unemployment benefits. Alimony or separate maintenance to the extent reasonably necessary to support the debtor. Alimony or separate maintenance to the extent reasonably necessary to support the debtor or a dependent. A catch-all exemption allowing a 800 exemption in any property. What does it say? A catch-all exemption? A catch-all exemption allowing an 800 exemption in any property. Exemption planning. By exemption planning, a debtor can restructure his or her assets to maximize the exemptions allowed. Exemption planning. By exemption planning, a debtor can restructure his or her assets to maximize the exemptions allowed by converting non-exempt property into exempt property. By converting non-exempt property into exempt property, assets can be protected for later post-discharge use. An example, $2,000 in a non-exempt savings account is better off held as an automobile, which is exempt up to $2,400. Example, $2,000 in a non-exempt savings account is better off held as also just buy a car, and you can. A debtor made so by converting non-exempt property into exempt property, assets can be protected for later post-discharge use, like sell it later or something. A debtor may decide to take out an additional mortgage on his or her house in order to reduce any non-exempt equity in the property and use the proceeds to invest in exempt assets. A debtor may decide to take out additional mortgage on his or her house in order to reduce any non-exempt equity. So they could take all the equity you built up into the house, everything you put down and you paid back, all that equity, that could be taken away. But if you take that out and you invest in exempt assets, so you're kind of like running away from them a little bit, but in a legal way. However, depending upon the facts and circumstances, a court may find that certain exemption planning constitutes fraud. Right. It is best to utilize a knowledgeable bankruptcy attorney for assistance in these areas. Like anything, you need an advisor. Of course, if Jerry had used the corporation, it would be the corporation's assets and not Jerry's personal assets that would be subject to the bankruptcy. Under that scenario, Jerry loses everything he put into the corporation, but not a lifetime's worth of his personal assets. So let me read this quote. It always looks as if the best way to solve a problem is to spend somebody else's money. Milton Friedman. It always looks as if the best way to solve a problem is to spend somebody else's money. Conclusion. Bankruptcy can protect certain assets so that a debtor may make a new start. Individual bankruptcy places all the individual's assets at the mercy of the bankruptcy trustee. So yeah, so if you're like a sole proprietor, or, corporate bankruptcy places only the corporation's assets into the bankruptcy, leaving the individual's assets protected. If you engage in an activity that could one day leave you, too, exposed to a bankruptcy proceeding, you are much better off operating as a corporation and not as an individual, sole proprietor, or general partnership. So I've done construction, and there's been dust getting on the other properties and shit. They could have sued. That's fucking sad, man. It's fucking sad. It's like that person was a swindler, bro. That and Jerry wasn't fucking being smart with this shit, man.